What is a transfer on death designation for financial accounts, and how can that assist you in your estate planning? My name is Michael Pevney. I am an estate planning lawyer. I practice in Southern California, and I help people all over the state set up estate plans. You can set up a time to meet with me for free by going to the comments section and going to my website, ocestateplanlawyer.com. So this is what a transfer on death beneficiary or designation is for pretty much every financial account that you have. And so here I'm talking about checking accounts, savings accounts, CDs, non-retirement investment accounts, retirement investment accounts, and even retirement accounts like a 401k or an IRA. Essentially, what that means is this money, this account will transfer directly to the person that you designate on this form when you set up the account or later on as you own the account when you pass away. And so essentially what that means is you present, your beneficiary presents pretty much a death certificate to that account, to that financial institution, whether you're working with a specific person or the institution as a whole, right? So you've got a checking account at Citibank and there's $20,000 in it, and you leave that to your spouse. And so the spouse, at some point after you pass away, shows up with their own ID and a copy of a death certificate, and then that money goes to them. They get that money. So that's essentially what a transfer on death, sometimes called TOD, or a payable on death, sometimes called a POD, can be used to do. So here are some advantages to a transfer on death designation. First, it avoids probate. So probate is the court-controlled, state-supervised, judge-approved asset distribution system that happens when somebody passes away with or without a will or a trust or something like that. And even if you do have a will, typically the will also has to go through probate. And where I practice in California, it has to be filed with the county that you typically live in or own property in. And first, it's very expensive. The average homeowner in the area where I live, the cost of probate is tied to the value of what you own. So it typically can cost about $50,000 or so to get things through probate. And it can take about a year and a half to 2 years, depending on the county that you live. Unfortunately, LA County is about the slowest. And even if we're just leaving something to kids, even just leaving a home to kids, it can take a couple of years just to get that home into their names. Now, the advantage of a TOD, a transfer on death beneficiary, is that it completely sidesteps, goes around, never has to go through probate because you've already said where you want this money to go when you set up the account or maybe changed the account. So it can be very convenient for beneficiaries to be able to quickly access the money in that account without the unnecessary delay of going through probate. It's also relatively simple to set up. So making a transfer on death designation or beneficiary can be simple to set up, and it can be simple to change. However, there can be some risks of having a transfer on death beneficiary. So you don't get to control how that beneficiary uses that money. It just belongs to them after you pass away. So if a life insurance benefit goes directly to a child or to a spouse, they get to use that money for whatever it is that they want to do. Second, it doesn't protect people against creditors. So if they happen to be going through a bankruptcy at the time or some sort of a legal judgment has already been filed against them, that money is open to being attached to by creditors because that money is now their money. And so if somebody got in a car crash or there's a credit card bill and there's been a legal judgment against them, filed against them legally in court, they can attach to your assets. It's much easier to do that, put a lien on property that you own. So it can also If you only leave one beneficiary, let's say you have 3 children, you make the oldest child the beneficiary with the idea and with the thought that that oldest child is going to give some of that money to younger children. So if there's 3 kids, you give the oldest child the money with the understanding that they're going to sort of split that money among all of the kids, all of their younger siblings. There's no legal requirement to do that. So sometimes, depending, the reality is this: when people pass away, sometimes that can lead to conflict. Even though people get along while you're alive, when people pass away and there's some money involved, that can lead to conflict. So here is a possible alternative to a individual as a beneficiary of a transfer on death account. Sometimes what we can do is we can set up a trust, and a trust can actually be a beneficiary of that account. So here are some benefits to a trust. First, similar to a transfer on death beneficiary, it will not have to go through probate. But what a trust gives you is much more control over how things are distributed. So let's say that you have kids, you want things to be left to those 3 kids. However, if they're younger, you don't want them to get access to that money until they reach a certain age, maybe 30, maybe 35, maybe 40, maybe even older. Maybe you want that money to remain in that trust and only to be used for specific things, like their health, like their education, like the health and education of maybe their kids or future kids. Maybe you want it so crystal clear that you never want anything to be possibly going to a spouse of those children or a potential ex-spouse of those children. We can have really write in extra protections there. Furthermore, this can also protect that beneficiary if they are going through some sort of legal trouble, a bankruptcy or something like that, because the money is inside of the trust. And typically we write in conditions there to where that money cannot go sort of right out the door to any creditor or bankruptcy or divorce type situation if that's going on when the trust actually receives that inheritance. So when you set up a transfer on death beneficiary, typically you need a few things. You need a name, and this is for a person or a trust. You need a name, you need a date, and you need some sort of tax ID number. For an individual, that's relatively simple: name, birth date, social security number. Now, if we're leaving something to a trust, we need the name of the trust. So, like if it's my trust, I'm married to, my wife's name is Heather, so it would be Michael and Heather as the trustees of the Michael and Heather Living Trust, dated December 12th, 2005. And so that's like the birth date of the trust, just like you'd use the birth date of an individual. And then there also needs to be some sort of tax ID number. Typically, a trust, if it's set up while you're alive, your tax ID number is going to be either you or your spouse's social security number. It might ask for an EIN, which is sort of like a tax ID number that might be given to a business, whether that's a sole proprietorship or something like that. Typically, we don't use that for a living trust at the time that you are alive. So that would be the name, date, and tax ID number if you wanted to make the trust a transfer on death or payable on death beneficiary. So basically, what we want to think about doing is first, always name a beneficiary to any account, because we don't want the money in that account to go through probate, whether it's a bank account, an investment account, life insurance. That can be huge. We also want to be careful about changing those beneficiaries, updating those beneficiaries, especially if there's a big life event that happens, especially if there's a divorce. Because if you get divorced and get remarried and the ex is the beneficiary on that transfer on death beneficiary, guess who's getting that money when you pass away? The ex, not your current spouse. And things are sort of pretty clear about that, about doing that. So, which is why oftentimes maybe we'll want to make the spouse the primary beneficiary, but as a secondary or alternate beneficiary, we're oftentimes going to want to make the trust that you set up, hopefully with a qualified estate planning lawyer, and not necessarily children as individuals, either, one of many children with the idea that the, oldest kid or most responsible kid is going to distribute that money to the other kids. So we want to leave it to the trust itself. And within that trust are the specific terms of how things are to be distributed. So that is just sort of a brief overview of a transfer on death beneficiary, how we can either name an individual or sometimes a trust as that beneficiary, the pluses and minuses to that, how we always want to make sure there is a beneficiary named. And with the trust, we do get some additional protections, especially if that beneficiary happens to be going through some significant life events. So once again, my name is Michael Pevney. I am an estate planning lawyer. Please follow this page if you would like more estate planning information. I put out videos fairly frequently. And if you live in California and it's time to set up that estate plan, you don't have one set up, especially if you own property or you have kids under the age of about 40 or so, you can go to the link to my website in the description, ocestateplanlawyer.com, and you can set up a time to meet with me for free and we discuss your estate plan. Got to live in California. I'm not able to help out people in other states. I'm definitely not taking another bar exam. So I appreciate your time and I appreciate your attention. Thanks.